Welcome to the Global Real Estate and Entrepreneurship Podcast. I'm Nicole, Forrester, real estate broker in Toronto with EXP, and I'm so glad today to be here with my very distinguished guest and friend, Demitry Omrin. He is an accredited appraiser and president and head mediator of the MediationLounge.ca. Welcome, Demitry.
Thank you, Nicole. Thank you so much. Pleasure to be here.
Demitry, why don't you take us down the path of, you in Toronto appraisals? Just to
Mhm.
give people a little bit of a background, Demitry and I met 20 years ago now, ancient history, when I was working at one of our flagship Scotia banks at Lawrence and Bathurst. At that point, I was a financial advisor managing a large book of business for them. And I had picked up the mortgage piece, and Demitry and his company, RECG.ca, was
Yes.
one of our preferred appraisers and appraisal companies. And so when I was doing a refinance for clients or a mortgage for them, I would absolutely reach out to Demitry for his expertise in appraisals. So again, he's been boots on the ground in the Toronto real estate market for many years. But talk to us a little bit, Demitry, how you got into this field and sort of the changes in the real estate appraisal field over your 34 years of extensive experience in the market.
Sure. Sure. Happy to do that, Nicole. Thank you for the question. So with real estate valuation, I got into it at the age of 22. It was after my experience in other areas of real estate when I was 20. My father was a real estate investor when I was a teenager. So my exposure to real estate informally was quite early. I was fascinated with the change in valuations when you would purchase a house or another property, commercial property, make certain changes, improvements, and how the valuation was altered, improved, enhanced. And so that for me became quite a fascination. So that is why I got into real estate formally. And at the age of 22, now 34 years later, still as a valuator and branching out into other areas where I'm able to use that knowledge and help people as well. The real estate appraisal itself, the process, is different for different purposes. So if someone is retaining a real estate appraiser per se to do a mortgage related valuation, that valuation being relied upon by a lending institution, that appraiser knows that there's a potential claim because there's a potential financial loss if the market was to change. So typically what I hear from client groups is that valuation would typically be more conservative than otherwise, than received from a real estate broker, a qualified professional real estate broker like yourself and others. So that is the most logical explanation that I've seen myself, because in theory, a property at any given point in time, if both Nicole and I appraise the property today, there's only one value for it. Now, it's not an exact science as to what value is. So if Nicole said it's worth 1 million and I said it's worth 800, there's a problem, there's an error. But if I said it's worth 950 and Nicole said it's 1 million, then there's a legitimate range by which we could say that valuation corroborates each other. So that's what clients should look for. Now, if they were to hire a real estate appraiser that has experience in disputes, whether it be estates or family law matters, any type of situation where there's an adversarial component to it, that appraiser now knows that that appraisal report's not going to be relied upon by a lender. There's less financial risk per se. So that appraiser, in theory at least, and from what I've seen, is freer to come up with a value that they feel is indicative of the market at the point in time that they're asked to do the valuation. So in family law matters, typically there'll be a separation date because that is the date upon which the family law rules in Ontario dictate the assets and liabilities have to be valued. If one spouse is buying the house from the other, and there's a protracted time between separation date and when one settles, then there'll be probably an appraisal of the property at current market value to reflect one spouse wanting to buy the other out. But at each point in time, whatever the valuation date would be, that appraiser is appraising knowing that there's not going to be a reliance by a financial institution. So they have more freedom, more range in determining what the value would be on fair terms. The report is written quite differently. It's written using what we call settlement-oriented language. So someone that's been to court and been cross-examined by opposing counsel understands the importance of making sure the wording is as tight as possible. While we're not lawyers, when we've been to court and we've experienced cross-examinations, we learn from that experience. We bring that to the next file and try and resolve as much as we can. The goal is to always make the report clear, concise. While the client may not agree with what the valuation determination is, we like to say that they at least understood how we got there, how we arrived at the number, at the figure. So that is, in a nutshell, the difference between the appraisals for different purposes.
Yeah. No, and there's a lot to unpack there. I appreciate
Yeah,
that. I know
yeah,
our audience is going to
yeah,
really appreciate that too, because so we're going to unpack all of that you just said there a
yeah.
little. But so number one, this comes up a lot that the appraisals come in lower than the comparative market analysis or a letter of opinion that a real estate broker would come up with. And sort of, Demitry, you really put it out there, why that is in different circumstances, whether it be mortgages, versus for separation or estate purposes that could go to court. These are great things to take a look at. So when I'm doing, because many times I'm asked to do a letter of opinion, which is based on a comparative market analysis for estate purposes and for separation purposes. But it's important for people to understand that comparative market analysis, and number one, I'm not going to court. You can pay Demitry, the appraiser, to go to court and use the court document for that. This is done as a guideline based on market value. And the way we do that is based on recent sales, based on our opinion. And for us, a market value is what one person will pay for a property at that specific property at that specific period of time. So we're riding the market wave. We're catching butterflies. We're trying to catch that wave. And definitely, we're more optimistic with our ranges than, let's say, accredited appraisers will be, who are going in with a magnifying glass and looking at every system in that home, and also willing to back up in court based on that, your magnifying glass of that property as accepted by the court as an expert. And that's my understanding, that you are accepted by the court as an expert appraiser. Is that right?
Yes, yes. So when we go to court, the process is that the side that I'm retained for, let's say it's the wife, whether it's the wife or husband, it doesn't matter. But one person is the applicant in a family law matter. One person is the respondent. So let's say my client is for the applicant. So we would typically go first. My lawyer client would introduce me at what's called the examination in chief. During that examination in chief, they introduce my report. I give a brief overview of the report. The lawyer asks me questions that are fairly open-ended to introduce the matter, the file, and my report, more importantly, to the court, to his honor, her honor. Once that is done, at one point, the lawyer will ask the judge, will you accept Mr. Omrin's report as expert evidence? And opposing counsel has an opportunity to either confirm that or object and challenge that. So usually it's a matter of credentials, experience, years of experience, past experience in litigation files, family law matters if it's for family law, and estate matters for estate files. So it's usually not an issue to be accepted as an expert, provided that you've had that experience previously.
And I want to make this point for our listeners so they understand, because this is a point that comes up often. So letters of opinion done by a realtor and a broker is for a guideline when you are in an amicable situation and parties can agree outside of court. When you are looking at, disputes between trustees and executors and in spousal dissolution situations, you're 100% going to an accredited appraiser like Demitry for that expert opinion and those documents. And there is a large
Right.
price tag that's on that as well, which is well deserved because it is a very detailed evaluation, and it's very time consuming. Now, also from a mortgage perspective, when mortgage refinances are done, or it's an appraisal is called in by a lender, these accredited appraisers are also needed because the lending institution is basing how much they're going to lend you, that this asset is worth. So once again, going in with the magnifying glass is important. And for these reasons, that is why generally these are a little more conservative than the ranges that a real estate broker will give you in a letter of opinion. So just to clear that up for everybody, because that's one that comes up all the time. So moving on to your court experience, I know that this has taken and your business has branched out into the Mediation Lounge, and you are the president and head mediator for this other aspect of your business. Talk to us a little bit about what you do at the Mediation Lounge.
Sure. So couples that are separating, when there's uncontested and contested divorces in Ontario. So uncontested is fairly straightforward. Couples may not have any assets of significance, or whether they do, they're able to resolve it amongst themselves. They simply go to a lawyer and they have the terms drafted in what's called a separation agreement, and then they're completed. The other more common situation is a contested divorce, where there are assets and liabilities that have to be arranged and determined. So there is a degree of disagreement. Sometimes it could be fairly acrimonious, and other times there's some degree of cooperation. So rather than going to court, retaining a lawyer immediately, couples in Ontario and throughout the country, in most provinces, what's called family mediation. My specialty as an accredited family mediator is to take them from A to Z on all issues relating to their matter, their separation. So whether it be the assets, liabilities, parenting and decision making, while my specialty is financial issues, assets, and determining liabilities with them, I do parenting and decision making issues as well. So there's a parenting plan that is encompassed within the mediation realm. But in pertaining to assets, people need to get all the assets valued as at the date of separation, whether it be real estate, pensions, credit card, even believe it or not, credit card points, cryptocurrency. People have all kinds of things with assets, cars, anything that has monetary value is considered an asset. The nice thing about mediation that a lot of people don't know is that you're able to deviate from the rules that the law and case law prescribes. So if you were to take your matter to court, a judge has limited maneuverability in the sense that they have to follow case law from previous precedents in terms of how they determine the matter based on the similarity of previous couples that have been through family court. Whereas in mediation, you can make concessions and customize your own resolution on your terms from A to Z. So you can do that on your own through the facilitation of a mediator, that essentially all that mediator does is help you have a conversation. In more acrimonious situations, we separate the parties, what we call shuttle mediation. When we think that they're able to bridge some of the gap and they've made some progress, we bring them together. Other times, couples are, while they may be in a state of disagreement, we're able to start off right together speaking. Before bringing people into mediation, we do what's called a screening process. So we screen for power imbalances, issues that may preclude or prevent a successful mediation. We don't want someone potentially agreeing on terms where they fear the other party, especially in family law matters where the conflicts can be emotionally charged, per se. So we want to make sure that if they do come to agreement, that it's on their own volition, not anything else. So there is a screening process that goes through the mediation process. We help them with everything in terms of asset valuations, liabilities, determining what the net family property value for each property is. We are familiar with the term net worth. In family law, it's called net family property, NFP. That NFP is determined for each spouse. The spouse with the larger or greater NFP has to give half the increment back to the spouse. So if one spouse has a net family property of 500,000, the other one has a net family property of 1 million, the one with a million gives half of that, 250,000, to the spouse with lower value, and now they're both worth the same amount. That's equalized. That's what equalization is in Ontario. That's how it works in a nutshell. I'm giving a simple overview. It can get more complicated, but that's in a nutshell how it works according to the rules.
Absolutely. And what a great thing, an important service to offer. Because it's been my experience that anytime you go to court, everybody loses. And
Yeah,
in that, there's an emotional toll that's taken. Even if you are, the party that is correct, like you said, case law can take precedence. There's many things that seem unfair that happen in courtrooms, even when you are, the just or the right party, and it makes sense. What actually ends up happening is not that in many cases. Many times it's the lawyers, and sorry, David, but many times it's the lawyers who get wealthy and they're the big winners when people go to court. So, number one, I encourage all people to exhaust their possibilities of settling disputes among themselves and having amicable dissolution of assets themselves. That's your best case scenario all day long for you emotionally and financially. But
absolutely.
Demitry is offering with mediation is a secondary level before going to court, before getting into a massive dispute where you have an educated third party who is working in your favor for the favor of your family to, amicably dissolve or come to an agreement, which will be better than going to court. I mean, there are times that you have to, and people are being unreasonable, but certainly it's an amazing service that you're offering to people to sort of be that mediator and that in between those two extremes. Because let's face it,
Yes.
when families are breaking up or their estate and lots of money is involved, there's emotions, there's money, there's fear of the new life that you may have and how much money you may or may not have going into that. There's just so many factors at play. So, what an amazing thing it is for you to offer our clients this next sort of layer and option. And you can reach out to Demitry and check out those services at the MediationLounge.ca. The other thing I wanted to mention about your organization, the RECG.ca, is that you also do not only residential, but you do commercial valuations as well. Is that right?
Right. Yes, that's right. So we're a full service firm. So anything from the matrimonial home to investment properties to commercial vacant land, any asset class that is non-residential, we can do. We're qualified to do that. We're designated to do that. So, and those cases would be where we can't wear two hats. So if we're retained as evaluator, then we have to stay as evaluator. If we're retained as a mediator, then you'd have to retain other evaluators. So we can't, it's a conflict to do both. But yes, we offer both those options to clients. And I should mention with mediation, people should be aware it's completely voluntary. At any time, clients can opt out of mediation. If they don't like how it's going, it's completely voluntary. They don't have to continue. Uh, and it's non-binding. So at the end, all they get from the mediator is what's called a memorandum of understanding, MOU. They have to take that to a lawyer and have that drafted into separation agreement. Only
Right.
when it's signed, it's only when it's signed, the separation agreement is signed and entered with the court, is it then enforceable as a court order. So the nice thing about mediation is if you're not comfortable at any point, you can leave. And it's usually done as called what's closed mediation. Closed mediation means it's without prejudice, which means you cannot use anything that was discussed against the other party if mediation fails and you're going to court or otherwise later on. So it's meant to be a safe zone, a safe haven for people to let their guard down to some degree and try and resolve matters.
And I fully agree. Look, you want to go pay lawyers and have make them have a Merry Christmas and give them all your money, go right ahead. But I would be recommending number one to settle it amongst yourselves as your first option, and number two, if that fails, definitely you want to check out the Mediation Lounge and Demitry's services because in the long run, it will save you a ton of money and aggravation. The emotional toll from going to court is just not worth it. So thank you so much, Demitry, for sharing with us today. And I encourage anybody who's going through this to reach out to him. And absolutely, if you need a an appraisal done, whether it's commercial or residential, I highly recommend Demitry as an accredited appraiser in his company. And I'm going to drop the link below in all the media for this podcast. Thank you so much, Demitry. Appreciate your time.
Thank you for having me, Nicole. Thank you so much.